All right, what's up, everybody? It's DreChilly starting a live stream. We'll wait for everybody to come on. It's going to be the creation of a trust plus Q&A with DreChilly. Okay. Okay, I see I got 3 people that's in the that's watching right now. I got 4. Can you guys hear me? Go ahead and let it be known whether or not you guys can hear me. Okay, I see I got. All right. T-Bat said, "Can I hear you if you already started?" Can you hear me now? What up, Gio? I got your hangout as well. Everybody can hear me, right? Okay, cool. All right, we're gonna go ahead and get right into it. I'm going to share my screen with you guys, and it's a short presentation and video that I made for everybody to watch. So you guys can go ahead and watch it, and then I'm going to go ahead and do the Q&A afterwards. I got a lot of things that I kind of want to touch on and I want to cover. So I'm going to be leaving this one up as well so everybody can go back and watch the playback on it because I want to cover various questions and a couple of emails that I had got, and I want to present a lot of things. So I'm gonna go ahead and get ready to play the video for you guys. Hang on one second. Uh, Share my screen with everybody. Okay, is everybody allowed to see my screen right now? Can everybody see my screen? Somebody in the chat room will let me know if you guys can see my screen. Okay, what about now? Might be a bit of a delay. Okay, cool. All right. So, and you guys let me know if you guys are able to hear it as well. Because I had to resynchronize my audio feed on it. So I'm gonna go ahead and play it, and you guys can go ahead and write down your questions if you guys got any questions after I play it for everybody. So you guys can go ahead and ask me the question shortly thereafter. But I'm gonna go ahead and play it for you guys right now. This is a revocable living trust example. Let me pause it real quick. Can you guys hear the audio presentation? Somebody type yes in the chat if you guys can. I want to make sure that you guys can hear it. No, DM, you didn't miss anything. And I'm gonna leave this one up so you can go back and rewatch it as well. Oh shit, you can't hear it. Hang on one second. Well, hell, you know what? I can upload it later, and then you guys can go back and watch it. Do you guys want me to go ahead and go over it to you guys what you guys know? Because I could have sworn that I synchronized and my computer acts a little funny from time to time. What do you guys prefer? You guys want me to go over the revocable living trust right now? Or you guys want me to upload it and you guys can go back and watch it on your own time? It's up to you guys, whatever you guys want. Okay, well, fuck it. I'll just go ahead and go over it right now. Okay, you got the revocable living trust. This is an example, and I'm going to drop the PDF format for you guys as well. Um, the purpose is always important because under the Uniform Trust Code in you guys' respective states, uh, the purpose has to be stated, and it has to have some form of clarification as it relates to a decedent's overall estate as well as the decedent's will. Now, why am I referring to everything as being a decedent or a dead person? Because commercially everything is bankrupt. So the fact that everything is bankrupt, everything and everybody operating in the public capacity is dead legally. So, um, okay, DRX Phoenix 88. I'll go ahead and cover it now. So the purpose of the trust is always important. So it goes on to say the purpose of this agreement is to establish a trust to receive and manage assets for the benefit of the grantor during the grantor's lifetime, and to further manage and distribute the properties and assets of the trust upon the death of the grantor. You want to see the Schedule A examples detailing the properties that the settler will be transferring to trust from the public capacity into a trust. Your commercial security agreement should also be held in trust. The funding of the trust. This trust shall be funded with the assets transferred to this trust by the grantor at the time of creating this trust or at any later time during the lifetime of the grantor, and any interest of community property transferred into or out of this trust shall retain its original character, and such property shall not be considered for public use. This trust may also receive property from any person or entity that is acting under the authority granted to the person or entity by the grantor. See Form 56. See, this is what I was talking to you guys about when I went over and I covered the Form 56 a little bit. See, they're acting as a beneficiary in a beneficiary capacity, and they are making you the surety trustee for the trust because you haven't came forth and expressed your trust orally in court, and you don't have a will registered with a trust involved in the will with the probate courts. And how you register a will is with the probate court is, you register it at the county level. So I'm gonna go ahead and let me get out of this real quick. Hang tight 1 second, everybody. I'm gonna stop sharing my screen. That way I can go ahead and go back. Okay. I'm gonna upload it later for everybody to play it, but I'm going to go ahead and kill the audio feed on it myself. Okay. Hang tight 1 second. You guys can hear it. Okay, the management of trust assets. A trustee shall manage and distribute trust assets for the benefit of the grantor and the successors and interest in accordance with the terms of this agreement. Trustees can be anybody you trust or assign as a grantor under the Power of Appointment Act of 1951. That's the law in which you guys want to go ahead and look up. It's under Title 26. I can't remember. I think it's Title 26 USC 20 Title 26 1241. But don't hold me to that. Go ahead and make sure that you guys look it up. Uh, I want to go over. I'm going to upload that video so you guys can go back and watch it. But I'm going to go over the trust itself. Hang tight. Give me 1 second. But for right now, while I pull that up, go ahead and ask some questions. Let's start with some questions. Anybody got any questions? Okay. Go ahead and ask them, DM. I'm uploading it, and I'm about to get ready to reshare the screen with you guys. The revocable trust, that is. No, not necessarily, T-Bat. What up, Alpha Majestic? Not necessarily. You can get one, but you don't necessarily. You remember the Social Security Trust is considered an EIN as well, so you don't necessarily need one. Uh, okay, I pulled it up now. I left off at the management of the trust assets. The trustee shall manage it and distribute trust assets for the benefit of the grantor and grantor successors and interests, and according to the terms of this agreement. Trustees can be anybody you trust or assign as grantor under the Power of Appointment Act of 1951. You see Form 56 IRS publication associated with Form 56. I then touched on a couple of topics, such as the payments during the grantor's lifetimes, payments to the IRS using the 1099 OID format, The fact that everybody is doing the 1099 OIDs, they are doing things totally wrong because they are not attaching the 8281 form associated with these security instruments or debt instruments that they are trying to redeem. Anything over the amount of $10 in Federal Reserve notes has to be reported on the 1040, but you have to have the CUSIP numbers associated with the security debt instruments that you are trying to redeem on the 1099 OID instrument list. The payments during the disability of the grantor. During any period that the grantor has a disability, the trustee may pay to or for the benefit of the grantor such amounts of income as principal, and trustee believes the trustee's sole discretion to be required for one, the grantor's support, comfort, and welfare, the grantor's accustomed manner of living, and any purpose that the trustees believe to be in the best interest of the grantor. Disabilities defined. For the purpose of this trust, disability shall mean any legal disability or the inability to provide prompt and intelligent consideration for financial matters for reason of illness or mental or physical disability. The determination of whether the grantor has the ability shall be made by the grantor's most recent attending physician. Trustee shall be entitled to rely on the written notice of that determination. And I got specific distributions. I talked a little bit about the commercial security agreement, the tangible personal property, residual assets, the trustees' powers. Let me go over number 6, trustees' powers. Trustee, in addition to the other powers and authority granted by law or out of necessity or appropriate for the administration of trust, shall have the following rights: powers and authority without a court order or without notice to anyone. See Rule 17 as the real party in interest if involved in a court case. Let me go ahead and I want to show you guys Rule 17 real quick. Hang on one second. I'm going to pull up Rule 17 and why I honestly believe a lot of people are losing in court because they don't understand standing. And this is why you have to have a trust registered. Let me share the screen real quick. Okay, can everybody see my screen now? I'm gonna answer that, Dr. Phoenix. That's a good question because in the restatements it talks about that. And if you look up your state trust code, the uniform trust code, it talks about where most of these states go off of the restatements of equity. Okay, cool, right here. So this is Rule 17. And Rule 17 covers the plaintiff in the defendant capacity in the public officers, real party in interest. Designation in general action must be prosecuted in the name of the real party in interest. The following may sue in their own names without the joining person for whose benefit the action is brought: an executor, an administrator, a guardian, a bailee, a trustee of an express trust. Now, where in any of those terms do you see the word plaintiff or defendant? So I got an email from a guy last week where he asked, apparently he's doing some work with I don't want to put their name out, but they got a case going on up in the northern district of New York, and they continue to get their ass steamrolled because they're not invoking equity, and they don't know how to invoke equity because they don't have standing. See, this rule talks all it's talking about is standing, basically. If you look at rules A through G, from the executor all the way down to a party that's authorized by statute, they don't have standing to actually even bring forth a claim because they are lacking capacity as well as jurisdiction to even pursue standing because there's no trust associated with the case. That's number one. Number two, I'm gonna scroll over and I want to you guys continue to let me know if you guys can see this because the one dude just asked a real good question. He said, what is a common law trust? Now, in the state of Arizona, it gives under Title 14, which involves the Uniform Trust Code. It talks about the common law of trust and principles of equity. A common law of trust and principles of equity supplement this chapter, except to the extent modified by this chapter and another statute of this state. The court shall look to the restatement. Now, when they say second right here, they're talking about the second edition. You guys can go ahead and order this from the American Law Institute right here. This is it right here, the restatement of the law. Well, this is the third word. Real quick, let me scroll up. Official text number 2. So this is how you do the research right here. You would go ahead and look at ordering the volume, which talks about the restatements and elements of the trust, the nature of the beneficiaries' rights and interests, and the modification and determinations of those trusts. Okay, and if you order volume 1, it talks about the characteristics and the types of trust and the creations of trust. All of these books are applicable to everything that's happening in these court cases, and people do not know how to invoke equity. So let's go back to that. So it talks about the court should look at the restatement, second of trust, for the interpretation of the common law and not to the subsequent restatements of trust to determine the rights and powers of the creditors and beneficiaries. You are a creditor, but you're an undisclosed creditor because you're not listed on the documentation of title, which under Title 46, what is it, 1201, talks about the certificate of title. So basically, the birth certificate, you become a creditor to the bankrupt estate via the birth certificate. Well, the birth certificate is essentially the receipt, but you are the authorized representative to the estate itself. And then it talks about number 2, the duties of the trustees to distribute to those whom a beneficiary owes any duties. Now, what are they doing? They're making themselves beneficiary to your estate because you haven't stepped forward and claimed executorship or trustee or presented the fact that you have an oral or express trust in existence. Number 3, whether public policy may affect the enforceability and effectiveness of the terms of the trust. Okay, so when they're talking about if you have an interest that is going, if you have an interest in trust and in equity that is going against public policy, then they might have a claim and they might have to, make some revisions to whatever it is that you are claiming that might be in your trust, and to effectuate the seller's intent. So if you have a claim in equity, and this is why that group of those guys, like I said, they're losing, and the court isn't responding because, for one, if the court is not responding to a suit in equity, then you would do a notary protest on the private side. And how they would go about doing that, and I hope this guy is listening because he said it would be on the stream this week. But if he's not, you guys can just pay attention to listening to this as well. And the reason why the court is not answering is because they don't have a trust set up in equity. See, if you going after the state or all these corporate figureheads, you have to get them in trust law because they are claiming to be beneficiaries as well as creditors. They're creditors on the private side, but then in the statutory side, they claim to be a beneficiary and they hold you as surety for the credit that they've used and that they will be receiving as beneficiaries. Go back and look at this right here. Number 1, the rights and powers of creditors and beneficiaries. So, hang on one second. Let me go over it with something else that I wanted to show you guys. So you take a look and you look at the Arizona Trust Code, and you guys need to go ahead and find it in you guys statutory rules of construction, or you guys revise statutes. And when you look at this, it will talk about the trust code, and it gives the definitions, the default and mandatory rules, the common law of trust, the principles of the governing law, the non-judicial settlement of agreements, which is applicable to the rules of construction as well as the Uniform Commercial Code. Now let's take a look at venue right here because this is extremely important. I think that a lot of people have never even, this is how you access the common law side of the court. See, these courts are operating and they got really 3 sides to them. You have the public, the private, and then you have what's in the common. Now, however, in the common, it's extremely, I want to say, difficult to get them to respond to your suit in equity, but you have to put in the work. You have to put in the research, and you have to look at your state's trust code to be able to hold them in trust. You keep them in trust law. You don't let them revert back over to admiralty. And this is where a lot of people get caught up at, because they revert back over into admiralty, and then you get caught, and you basically, they pull you under. So venue, it talks about, except as otherwise provided in subsection B, venue for judicial proceedings involving a trust is in the county of the seat in which the trust principal balance of administration is or will be located. Okay, if you think about it, where the most criminal matters take place at, they take place at the county level. Unless somebody is involved in some big time shit, the feds will come knocking in. But for the most part, you know, people that's getting caught with a little bit of weed or dime rocks and stupid shit like that, you are getting placed in a venue that involves administration at a county level. And you don't understand trust law, so you don't have a chance in their venue. And nobody ever challenges venue, because what would venue be applicable to? It would be applicable to probate court, not the county level courts. But nobody ever raises the argument. So the fact that you never raise the arguments, thank you, Alpha Majestic, I appreciate that. The fact that you never challenge venue, see, everybody goes in and always challenges subject matter. That's cool, but challenge venue as well. If you're going to challenge subject matter jurisdiction, you always go back and revert and you challenge the venue, because right here under the trust code, it talks about venue. If trust is created by will and the estate is not yet closed in the county in which the decedent's estate is being administered. So that's the other side of the court. You got the probate court that's operating in the private of the common law if a trust is registered, and it will be administered at the county level. If a trust has no trustee, venue for judicial proceeding for the appointment of the trustee is in a county of the state in which the beneficiary resides, in a county in which in which any trust property is located, and if the trust is created by will. Once again, the trust is basically a descendant to the will, in the county in which the descendant's estate was or is being administered. So it was something else that I wanted to show you guys. Now, I want to talk about, that's what I want to talk about, and I'm gonna get to that video. I don't know if you guys remember, but this video was pretty, it got a lot of views on YouTube. And I want to explain to you guys the significance and how he basically sunk the court from dry dock. He basically used a common law approach, because in this video, this man expressed his trust orally. That's what I wanted to touch on. And this video is a good reminder of that. He expressed his capacity and standing from the land, which is the common law, to the seas, and he actually got the judge to leave the bench. So I don't know, I can't play the video for you guys, but whenever you guys get a chance, I want everybody to take a look at this case. This is the video in which this man, it's called Case Dismissed, Challenge Your Straw Man in Court. And so now, when what basically he did was he formed an oral trust, but he did it from dry dock. He didn't cross right here. He didn't cross the bench or the bar. He didn't cross the bench or the bar, whatever you prefer. And he expressed his trust to the bailee. Now remember, when you go back and you look at Rule 17, a bailee, the bailee also acts as a guardian in this position as well, because they're guarding the expressed, because he did a orally expressed trust in court. And upon doing so, the bailee had no choice but to take on guardianship role of his trust. So when he expressed trust in court, the judge basically bowed down to him, because here is the fidelity bond. We're not, oh, you could call it a fidelity bond, but basically here's the documentation of the actual vessel as it pertains to Title 46, and this is the real defendant. Now, I'm a real party in interest as the trustee, but I'm not the defendant, because those are the terms that this particular court is using. So, hold on one second. Let me go ahead and I wanted to go ahead and go back, and then I'm going to look into the comment section, and I'm going to start answering some questions for you guys. So let me go back. Give me 1 second, you guys. I get situated a little bit, and then I'm going to go ahead and start answering some questions. I'm going to upload the video later, the presentation that I did for everybody. I'm gonna put a link inside the presentation so everybody can go ahead and look at it. Okay, I'm looking at my chat room. Let's get into some questions. Sammy J, can we claim the liens that are in the straw man name? If you're a secure well, why would you want to? If do you own the liens? I mean, if you the commercial security agreement is essentially uh the notice of lien, or the UCC is the notice of lien. The commercial security agreement is essentially the lien itself. Uh, but the commercial security agreement should also be held in trust. Challenging T-Bat said challenging venue at the county level will move it from probate to the common law court. Is that what you're saying? Correct. Correct. You have to look at, but see, when you that's a very good question that you just made. It will move it, but if you're going to use the trust instrument instead of expressing it orally, if you got it in writing, you would send it registered restricted signature to the presiding judge, and you would attach Form 56 under the Power of Appointment Act as the grantor and make him responsible for the taxes. And upon doing so, they're not even really going to want to fuck with you, because now basically you have formed a trust in court and you're holding everybody else in equity. Trust law is the way. Going exactly. My pleasure, bro. This channel deserves all. I thank you. Appreciate the alpha. Aaron McCollum said that happened to me, but I recontracted by understanding. Did you who did you recontract with? The court? You can contract with them, but that video was so dope what that dude did, because I don't even think that people understood when, even at the end of the video, you guys go back and watch that video that I plugged as well, because even at the end of the video, remember how last week I told everybody, I said, okay, when you can sign anything, but when you sign it, you have to explicitly reserve your rights. And he did so at the end of that video, because he dismissed court, and upon dismissing the court after the goddamn judge ran off the bench, he said this case is now dismissed with prejudice. He didn't dismiss it without prejudice. He dismissed it with prejudice. Alpha Majestic said, I've seen a great video. The judge bows before leaving the court. Exactly. They put it in our face. They not hiding anything, Gone Spoon said. Exactly. DM said, how do we get employers to pay taxes? What forms do we use? Well, you got to understand what is a tax. That's number one. And then number two, you need to go read the IRS manual 6209, and you need to understand that all of these so-called taxes, there's no such thing really as an employer tax. I mean, they pay corporate taxes, but if you're talking about the taxes that they withheld from you and you want to make them liable for it, then you would hold them liable for filing a W-3 that is naturally fraudulent, and it's incorrect. Everybody's W-3 is incorrect. Everybody's W-3 is incorrect. T-Bat said, when you're saying holding everybody in equity, what does that mean? Meaning that you are holding all the parties that are not inside of your trust at fault. That's what that means. You're holding them at fault. They're not beneficiaries. They're not, you haven't appointed them. They're not trustees. They're not they're not a real party in interest. That's what I mean. So the fact that they're not a real party in interest, how can, like I said, if you look at Rule 17, where does it state that you got a plaintiff as well as the defendant? It doesn't. Let me scroll back up, because there was a few questions. I want to make sure I didn't miss anybody. Let me scroll back up. Okay, I think everybody was just kind of talking a little bit up top. DM, you said you had a boatload of questions. Go ahead and shoot them. Going Spoo says, do the CEO of corporations have oaths to do business with the states? No, no. Once a business is registered, it just has a statutory agent or a receiving agent, and if it's a LLC, the liability falls back on the company itself. Which is why, if you understand what's truly going on, uh, the name of the game is bankruptcy. Because how, like I said, how you gonna have creditors and debtors? How you gonna have a creditor and debtor situation and there's no fucking money? Which is why I laugh when I hear people say, "Oh, such and such filed bankruptcy." If basically these motherfuckers is getting away with highway robbery, because if you able to get an alleged creditor to finance whatever it is that you're trying to do under the LLC, and you reporting even on your corporate tax returns that the LLC is basically breaking even and doesn't have enough money or cash flow to be able to repay creditors, and you come up with a bankruptcy contingent plan under Chapter 11, you're getting over. The only thing you got to do is basically, file for bankruptcy. Not saying that I prefer to. You guys, President Donald Trump is a prime example of a motherfucker who has done shit like that. You take somebody money and you tell them to fuck off, and then you basically file bankruptcy on the LLC itself, and then basically you basically then gank the motherfucker. You can't handle the truth. Said, what name should you use on the trust? You want to use damn, I covered that in the video. You want to use the uppercase, lowercase as the trustee, and then the name of the trust is naturally going to be your straw man in all caps. But you want to put revocable trust right behind it. T-Bat said, you said send a trust document to the judge via certified mail before court hearing. I prefer, if I said certified, that's my mistake. I prefer sending it registered mail, restricted signature to the judge themselves. That way, it's because the judge knows what, I mean, the prosecution know what's going on as well, but the prosecution, you kind of want to keep them in the dark on it, as well as the judge. The judge usually wants to keep the prosecution in the dark on it and just dismiss the shit. And I'm quite sure the judge will pull prosecution's coattail and be like, look, this motherfucker know what they doing. They didn't already sent me the trust, and I prefer to express it orally as well. And you say, I am here before this court as a member of the prosperity, holding you to your binding oath of office pursuant to the United States of America Constitution. I am expressing the irrevocable trust in the name of the decedent. Then you give your name, and then you say that's orally, and then you say, on and for the record, I would like to present this court evidence that you have signed for and received the irrevocable or revocable trust, whichever you prefer, via your signature, return receipt requested. So you said you send the trust document to the judge via certified mail before the court hearing. Are we sending an entire trust document, or is only sent to the judge or any others, prosecutor or court? No, you never file. If you file it with the court's clerk, you enter it back into the admiralty. Remember, common law is all private. It's on the private side of the court. So you wouldn't do that. You would just simply, send it through the mail. Remember last week when I told you guys, I said, you guys got to understand the power of a P.O. box. Rome G talked about that a little bit last week as well, when he said you can basically conduct court through the mail, and a lot of people didn't catch that. Can you get a copy of what statement? Oh, well, shit, just go, man. That was off the top of my dome, man. Just go back and listen to it, yo. Yeah, that was off the top of the dome. I would say start with the living, because you dead at sea according to them, because you're using they dead entities money, but you are a living man or you are a living woman. So you would go ahead and still work on your living trust document first. And then as the settler, you attach your Schedule A. Like I said, I'm gonna go back and upload that video because I covered that shit in that video, and it wasn't, you guys can hear the audio on it, but you basically would go back and you would attach all your property on your Schedule A. Aaron McCollum, you had a question earlier. You said something about the fact that you contracted with them or something along those lines. And with the gentleman who sent me an email, if you are in the chat, can you go ahead and drop the question that you had as it relates to credit cards? Yeah. What's the advantage of each revocable and irrevocable? Well, the irrevocable is basically that's just it. Can't shit in the motherfucker really be changed. I mean, you can always go back and change it, but then you gotta, you know what I'm saying, amend this, amend that. And then remember, if you're a secure party creditor, the commercial security agreement is in there as well. So you got to go back in here and rechange all the UCC1 financing statements, and then you got to, file for an addendum and all that old shit. Whereas the revocable one, you can orally revoke it as well as expressly you can express it in writing. So that's the only difference, but the advantage is that, like, if a motherfucker's on a deathbed, you kind of want to, if you got everything set in stone and you in your right mind still, but you just, like, getting ready to pass over, then you make it irrevocable. That way, you can't have nobody come back arguing over, daddy's old work boots and his old wallet and shit like that, But come with some more questions. It was something else that I wanted to show everybody tonight as well. Shit. Oh yeah, that's what I wanted to show you guys. I wanted to show you guys the 6209. I really don't like going over that shit too much, but I'm gonna go ahead and show you guys the 62 6209 IRS manual. Here we go, right here. Okay. T Bat said, could you explain how the power of operating in trust in court benefit in a family court case in regards to child custody? That's kind of a complex question, but hold on. Let me break that down for you real quick. I'm gonna get back to that. I'm going to answer that question, but I wanted to show everybody something real quick as it relates to the IRS in regards to that one gentleman's question. He talked about, taxes and shit like that. Okay. I'm gonna get ready to share my screen again with you guys. Okay, there you go, right there. Hang on 1 second. Okay. This right here is the IRS the tax returns and the forms right here. And you guys look, you can see that the W-2 is a wage and tax statement. And it's the tax class right here is as a class 5, along with the W-4. Hold on, I'm gonna scroll down and show you guys the W-3, which your employer has to file, as well as the W-4. It's all class 5 taxes. And so now when you go over it and you figure out what a class 5 tax is, you look into the estate and gift tax returns. Remember, why are W-2s, W-4s, W-3s, why are all of those things estate taxes? Because you use the name of a decedent. The all cap letter name is dead. So you would go ahead and you would look at the, I gave this out last week, the 21 7-5 estate and gift tax return. Okay. So now, let me go back. And I'm going to get back to answering some questions, but that's what I wanted to show everybody. Did everybody get that? Was everybody able to see that? Okay, let me go back into the actual live stream. Alpha Majestic Dre, I will be emailing you again as well. I think the first email got buried underneath it. Hell yeah, it probably did, man. I got hit up about what shit, probably like damn near 30 emails, but they don't never bring their ass to the chat room and ask their questions. But anyway, it is what it is. Aaron McCollum said it was verbal contracted by agreeing that I was Aaron McCollum, all caps, to the grand jury after the other judge was reprimanded. Exactly. You going and you motherfuckers going in a contract all their rights away. You can remember you can orally contract your rights away just by having a minimum of contacts with them. DM said, "Am I able to challenge a notice of claim that the state made against me?" Of course, but do it in equity. That's what I'm talking about. Do it in equity. You have to have a trust. Listen, without a trust, you don't have capacity. Under Rule 17, it says nothing about a capacity of a defendant or a plaintiff. Neither one. Sammy J said, "What's the difference of filing miscellaneous as to filing public?" You got to give more reference as to what you're talking about. Just retype your question. Go and Spoo said, "How would you claim back your greenbacks on an OID if there is no payables being sent out?" They're not sending out payables because they use grant blocks. And, some of them do. They'll send a check and they'll say, what you think is a actual billing statement, that's actually a fucking money order, but you have to convert it into a payable. So if they don't, anything with a amount on it can be sent back to the Department of Treasury. Okay, you can't handle the truth. I'm gonna save this live stream as well, so you can just go back and look at it. But basically, I wanted to show everybody underneath the 6209 that all W4s, W3s, and W2s are Class 5 gift and estate taxes. So why is everybody filling out 1040s? You don't report income on a 1040 unless you are going to do the 1099 OID along with the 1096, the 1040V, which is the payment voucher. But where everybody is fucking up is exactly Sammy J A4V correct. See, where everybody was messing up back in the day is that they was defacing the actual coupons by writing all that crazy shit on it. You got to write it at a slanted angle. You got to do this. You got to do that. And that's because nobody was reading the Uniform Commercial Code. That's what I wanted to get into as well, Sammy J. That's a good point that you just made. Let me go ahead and find that real quick. I'm going to go back to Cornell, and then I'm going to go ahead and get into the UCC a little bit. We're going to really get into this and chop it up, and we're going to break this down. Because what they're sending you is negotiable instruments. They call them debt instruments underneath the Internal Revenue Code, but really they're negotiable instruments under Article 3 because the commercial law is applicable to the tax law. And if you don't understand how those are interrelated, you're really going to be fucked up. So let's go ahead and let's go take a look at UCC 3-104. Okay, hold on. I'm going to share my screen again. You said, Geopolis said, is that like the 1040V is actually a money order? Exactly. The 1040V is a money order itself. Inside the trust, shouldn't you put property and other assets in an individual trust? Exactly. And I said all of that, and I'm going to drop the PDF for you guys to look at it as well, so you guys can get a formation of how you will write it. But you still need to go ahead, and it is mandatory that if you want to create a trust, it's mandatory that you look into your state's uniform trust code, because as I just showed you guys in Arizona, it shows you how to formulate one. I didn't go all the way down, but it had a lot of the statutes that basically tells you how to register one, how to create it, what must be required in order for it to be considered a legally recognized trust, and all of that. But hold on, I'm going to get into the UCC a little bit as well because he mentioned a real good point. Sammy did where he talked about the A4V the correct way. So let's get into the UCC a little bit. Nobody reads the UCC, and this is why y'all getting y'all asses handed to you. I just got an email the other day, last night, in fact, where I don't even want to go there, but just know that you getting tore up because you running around and you listening to all of these crazy ass motherfuckers on YouTube, and they never show proof of claim, and they don't read everything that involves court, if that makes any sense. So whenever the people go to court that y'all listening to, whenever they telling y'all to go to court and do all of this crazy shit and y'all putting in all of this paperwork, the clerks, the paralegals, everybody down there, the court commissioner, when they see that shit, they laugh because they like, man, another one listening to these crazy ass people on the internet telling them you can file liens and against public officials that haven't even done nothing wrong, and then you want to hit me up talking about, you know what I'm saying, you got a criminal case and you don't know how to get out of it. You don't know how to get out of it because you don't read the Uniform Commercial Code. So let's get into 3-104. Except as provided in subsection C and D, a negotiable instrument means a unconditional promise unless you make it conditional, and I'm going to show you guys how you can make it conditional. It means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order. Okay, what is the elements of the check? Pay to the order of, right? So this is how you would do A4V correctly because it is a negotiable instrument that they are sending you. What you think is a bill, that coupon is a negotiable instrument, but only you can endorse it because you are the authorized representative. One is payable to the bearer or order at the same time it is issued or first comes into possession of a holder. You are also the holder if they send it to you. Two is payable on demand or at a definite time, and does not state any other undertaking or instruction by the person promising or ordering payment to do in any act in addition to the payment of money, but the promise or order may contain an undertaking or promise or power to give, maintain, protect collateral to secure the payment, an authorization of power of a holder to confess judgment. Remember, you guys are confessing. See, this is why you're losing in court. You're confessing judgment against yourself when they send you the tax bill, which is the indictment. Pay it. Don't confess default judgments. This is why you when you go in and you arguing and you're not paying it on the tax end, they tearing you up because you're doing confess judgments against yourself. Judgment or realize or dispose of collateral, or a waiver of the benefit of any law intended for the advantage or protection of the obligor. Let me go ahead and I want to show you guys how you do it conditionally. Hang on one second. That's UCC right here. So you would Article 2, 2-207. You conditionally accept they ask. Additional terms and acceptance of or confirmation. A definite or seasonable expression of acceptance or written confirmation which is sent within reasonable time operates as an acceptance, even though it states terms additional to or different from those offered or agreed upon, unless acceptance is expressly made conditional. This talks about a conditional acceptance on assent to the additional or different terms. So when you guys get a traffic ticket, you can conditionally accept to pay it as long as they give you the 1099 OID for it. But as the dude in the comment section just referenced, he said, how can you make it a payable when they're not even sending you the check to pay it? Well, they usually wait till it gets into collections because they run up the tax bill, which, compounds in interest. This is what's happening. So they'll wait till if you don't respond to it, because remember, it says a definite and seasonable expression of acceptance as long as it is within a reasonable time frame. it operates as acceptance. So you can either conditionally accept it, or you can reserve your rights. I'm gonna show you guys how you reserve your rights as it pertains to the UCC. So you would go back into the UCC. Nobody reads this. You guys got to start reading this. You got to learn this, because you have to learn how to operate under commerce, because everything is in, it's under the Uniform Commercial Codes. There you go down to the territorial applicability and general rules of the UCC, performance or acceptance under the reservation of rights. Okay, hold on, you guys. I'm gonna get back to you guys' questions, but I want to get into this UCC. So you look into UCC 1-308, performance or acceptance under reservation of rights. A party that is explicit with explicit reservation of rights. Because remember, in that video that I want you guys to go look back with that man, he explicitly reserved his rights, performs or promises performance or assents to the performance in a manner demanded or offered by the other party, does not thereby prejudice the rights reserved. Such words without prejudice, but he said with prejudice, meaning that they ass can't come back, or under protest or the like are sufficient. This is how you see this. Man, that video was so cold, and I'm surprised that they haven't snatched it down yet. But that video was so cold because he showed basically how you throw a goddamn bomb at the judge who's on the water from the land, and he did it via the birth certificate. But at the end of the actual case, man, it was so, that video is so cold, right? Because look, check this out. Let me break it down. In that video, he expressed trust. He handed him the negotiable instrument, which is also the birth certificate. So he turned over the defendant to the court. So they got the defendant. So now they got the performance aspect of UCC 1-308. So he performed because he handed over the defendant. And also, he reserved his rights under the land, because he never actually crossed the bench. So he was basically still on the land. So he reserved his rights under the common law. This is how you do it, man. That shit was so cold, man. That video should have well over 20 million, you know what I'm saying, views, yo. Easily. But it is what it is. So hold on one second. I'm gonna stop screen sharing, then we're gonna go back and I'm gonna look back into the chat room, and we're gonna get back into the questions. Hang on one second. Okay. Let me scroll back up. Geopolis said, "Is that like a 1040V? Is that actually a money order?" Yeah, that I answered that one. They didn't understand. Golden Spoon said, "You can't handle the truth set inside the trust since you put property and other assets in an individual trust." I read that one answer. Marie said, "Yeah, man, I went to my tax guy and he had no idea about those forms that you mentioned, which showed me people are really blind to this, which means I need to learn and do my own taxes." Exactly. You have to listen. You're the pencil man for the estate. So when they coming after, they hold you as surety. So you better learn. Like, people think this is a joke or this is like a game. You have to understand tax law, because the law merchant, whether you understand what you're doing or not, you are being held as surety via the birth certificate. If you're not a secured party and the status is not corrected, you are being held as surety to the birth certificate. So any debt, bills, obligations, letters of credit that you run up, any of that shit, you are responsible for the taxes. So you better learn and start understanding how to operate under trust law, tax law, as well as the Uniform Commercial Code. So then Richard Rhea said, "What's the remedy for a closed Chase credit card that was closed because it was maxed out, showing only 2 months late on Credit Karma at the presentment?" Okay, are you I think this is the gentleman that had sent me the email. He said, "What's the remedy for a closed Chase credit card that was closed because it was maxed out, showing only 2 months late on Credit Karma at the presentment time, at this present time?" You got to go through the DTC on that if they already closed it, because the account itself has probably already been rebonded, resecuritized, and they done already sold that account internationally, but it's never really actually closed. But Don't try to. I know that prick. That I don't even want to give him no shine, but that prick have fucked a lot of y'all up by trying to, use those closed bank accounts as well as those closed credit lines and run blank checks to them and stuff like that. But if I'm you, you need to give Fidelity a call and get the QSIP number associated with the credit card and pay the tax bill that's due. Have them write Chase a letter, have them, say, okay, make them a presentment. You make them a presentment under the UCC, and you tell them that you want to settle the account. That's how you do that. And then you reapply, and then they'll give you a new line of credit. But the line of credit that you're referring to has probably already been sold through the DTC. GeoPoly said 1040 say payment voucher across the front. That's my money order they gave me, correct? Exactly. From my understanding, Sammy J said, from my understanding, in order to discharge debt with bonds, A4B promissory notes, you have to create your bond and claim it on your collateral section. Discharge debt will not work properly. That's because nobody is, like I just said, nobody reports it. Listen, you got to report it all on the 1096. That's the only time you report it on the 1040, because remember, they're using what's called a block, a grant block against your line of credit, because they have direct access through the Federal Reserve to access that account. At the county level, the state level, all of these courts are nothing but banks. Let me go. Can you throw a video link in? I'm just getting in. Yeah, I'm gonna go ahead and put it. I'm gonna leave this one up, and I'm also gonna upload the presentation that I did for you guys. You can file a 1090-C on a judge making income to him. He got to pay up exactly. If it went to collections, you have to send them debt validation letter. Yeah, I did the video covering that, Sammy J. But people, they still got it on their credit reports because they don't know how to operate and enforce the letter and consolidate the reporting agencies along with the alleged creditor. If you don't even know how to do that, then I mean, it's only so much I can do. If you don't even know how to, write a letter, you don't know how to write a letter and consolidate people and do an administrative process to where they are held liable for misreportings on your credit report, that I don't know what to tell you. Name those 3 laws to learn once more. Tax law, Uniform Commercial Code, which is basically a law, a whole law within itself. So you got tax law, trust law, and the Uniform Commercial Code. And when you look into trust law, you need to look into getting those books. They're expensive, but the restatements of trust, second edition in particular, is what a lot of these states are using. Richard Rear said, "Thank you, sir." Oh, no problem. I think, yeah, that was you who sent me that email. Tried to email you, but it came back as failed. Yeah, that's correct. That's the right one. I don't know why. Billy Two Guns, in the NY case, it will be a private trust. How would this hold the defendants liable? It will hold the defendants liable because you accessing. Okay, I got you. I got your email too, as it relates to what you guys are doing up in New York. I didn't get a chance to fully go back and read everything that they were claiming, but I think that it was some grievances that you guys wanted redressed in the actual complaint. I will have to really look back into the actual complaint itself, Billy. You know what I'm saying? But I do plan on going and looking into and seeing what you guys got going on. But they're not responding to you guys because it sounds like, from the overall scope of the email in which I received from you, the court are not responding to you guys because you don't have a suit in equity. Remember how I told you, like, you guys got to get them in equity, and the only way you can get them in equity is by providing a trust. But if the trust, you guys got to just name everybody that's in the complaint as trustees to the actual trust. You guys got to formulate your own trust. So basically, I would tell you guys to actually scrap the lawsuit and then come back and formulate the trust, and everybody that is involved with the trust be able to present it on the private side of the court, and then you guys might be able to go ahead and get the court to respond to your complaint. If the court don't respond to your complaint, do an administrative process on them. Do it in a minute. Do an attack. See, this so cold right here. This shit might get me shut down. What I'm about to say. Do a taxable administrative process on the court. I bet you a lot of people ain't never even heard of that shit. Do a taxable administrative process on the court for failure to respond, and start fucking building them. And I guarantee you, y'all get a response that way. Where can I read about the grant block? There's various publications on that. I mean, hell, just type that in. You know what I mean? You'll see what I'm talking about when I say that. They just basically they don't send you a check because they want to access the credit and run up the goddamn reportable net income on the 1040 as an individual instead of it being reported from the estate, which is why I showed you guys the 6209. They want to run it up on the individual side, which I have still yet to see what the fuck a class 2 tax is, or the publication concerning it. But yeah, Billy, y'all need to do a administrative process on the court. Produce a taxable claim, and if they don't respond to it here in the United States, take their ass to the Bank of International Settlements. Y'all can access that court as well. Go international with them. They not even gonna let it get that far though. Come with some more questions though, everybody. DM registered trust with the state. Is there anybody else I need to? Uh, your fiduciary. You want to appoint. Get you a trust lawyer. Don't get me wrong, man. They are needed because you just get you a good one. You know what I'm saying? If you're gonna go for broke, go for broke. Get you a good, estate planning and trust lawyer, yo. That's how you do that. And have them make sure that they have a little bit of experience or some type of educational background as it relates to tax law as well. Okay, Billy Two Gun said, okay, Geopolis in Illinois, they won't let you file UCC in the name. Is it is the as the business name? How do you get around that? But remember, the actual straw man belongs to the DTC. Let them have that. But how you circumvent that is registering as a trademark. See, not as a trade name. Register it as a trademark. And then when you register it as a trademark, just switch the names around. So instead of putting it in your name, because I heard people say that where, yeah, they would say, well, this is the same person. So you can't have it in the same, it can't be the same as the two names can't match. So you can name the damn trust whatever you want to name it. T-Bat said, can you answer my previous question about the benefits usually of a trust in regards to family court and child custody? Well, it gotta pay. Listen, it depends on the situation in which why were the children taken? Because remember, the children are abandoned and belong to the state anyway. They wards of the state. Me saying that sound fucked up, but basically the children are wards to the state. So you're not a real party in interest under no applicability as it relates to Rule 17 because they are minors. They haven't reached the age of majority. But if you want to go ahead and elaborate and give some type of background so I can see what's going on, I mean, I gotta have a fundamental understanding of what's going on. Because remember, unless you have explicitly reserved the rights as a signatory to the birth certificate, which creates a vessel, which is, all under the Department of Shipping and Commerce, if you haven't reserved the rights to the child being the guardian of the estate to the child, then by default the state claims parents portrayed. So you don't have a you don't have a suit in equity, or you don't have a suit in I mean, you can come in and you can play the little bullshit game with them and make a tax issue out of the case. But if you go in there arguing, which I think that would be my angle to kind of like answer your question, but I don't know the circumstances in which why the children were, taken from the custody of the custodial parents. But like I said, you can go back and try to get them in escrow. No, I said that wrong. I said escrow. I mean, you can try to go back and get them and play that game as that whole plaintiff defending shit. My mind is on that real estate shit, y'all. I'm talking about escrow. But hey, truth be told, when you're in jail, you're being held in escrow. See, I bet a lot of people didn't know that. That's like, that's a whole nother subject. When you are in jail, you're being held in escrow. Uh DM said planning on having a child soon anyway to avoid the hospital SS5. Like I said, you could sign it, but sign it and reserve the rights. Reserve your rights as the conservator as well as the guardian of the estate. Go read Rule 17. That's how I know that people be like lying, like when they be saying like, oh, because I said that shit last week, like, the hospitals, they not gonna let you take no kid out of the goddamn hospital because all hospitals are on military ground standing rules. All hospitals are. Now, if you have, who's real good about that? That community, the Quaker community up in the Lancaster, Pennsylvania area. But see, that is a whole, they get respect because they don't have any adhesion contracts with the United States to begin with. So the United States corporation respects them and leave those people alone because they haven't contracted with anybody. They don't have child births at hospitals. They stay within their own secular communities. They don't basically have any dealings or commercial affairs or adhesion contracts with the corporate United States. So therefore, they are naturally exempt and they don't come, bothering them. You see, I thought the state was heirs of the descendant anyway. Well, that's because everything is abandoned. People abandon the shit. The child support agency holds children hostage, then charged to pay rent for the on kid. Sad but true. Can you email me, please? Because I tried to email you and came back. It's failed twice. Okay, yeah, I'm gonna make sure that I go ahead and shoot you an email, yo. But if you got some questions you can't handle the truth, go ahead and ask them now. Uh, Alpha Majestic, let me go back and reread yours. You said the child support agency holds children hostage, then charged to pay rent for the on kid. Sad but true. I know like a lot of people that caught up in child support cases and stuff like that. The Department of Economic Security handles the presentment aspects underneath the Uniform Commercial Code. And they use, in the state of Arizona, they use a clearinghouse to basically do the exchanges and shit like that. But truth be told, a lot of that stemmed from the mid 90s when Clinton kicked a lot of women off welfare, black, white, polka dot, whatever. And they start going after, they basically found another way to create a whole another like monetary system via child support. Now, a person should be taking care of their children. You don't get stripes for it. It's something you should be doing just because, you had the children. So they shouldn't have to make your ass, take care of your children. But no, you good, Alpha Majestic. But truth be told, Clinton passed the law, and I believe it was the middle of '96, and he kicked a lot of women off welfare and shit like that. And they went back and they went after a lot of the fathers that had signed the birth certificate and made their ass liable as a guardian, but they didn't have custodial rights, basically. That's what was happening back then. She's saying child protection. Geopolis said she's saying child protection services is charging the parents for the children's rent when they're held as wards. I think that's what she's saying. Well, damn, if that's the case, that is pretty fucked up. Like, I mean, like, shit, the children are already, yeah, you property of the state. Exactly, Mo. You said it right, property of the state, right? Exactly. The children are already technically property of the state because after 7 years, they considered lost at sea because you signed them up as being a vessel under Title 46. Um, via the birth certificate. But damn, that's pretty. I had never really heard of that type of stuff. I mean, some stuff that you guys keep coming with the questions and just even statements because, like I said, I'm learning a lot from you guys as well because a lot of that stuff I'm not involved with it, so like I don't know everything in which these courts are moving, how they moving against the people. I mean, I know the whole child support racket, I know the whole tax racket, I know, but like for shit like that, I had never even heard of the state doing that. Basically, she got to pay for the children's rent for being held as wards at a damn like orphanage. Yeah, that's pretty fucked up. Now, when they send you the bill, you can charge it back to their accounts, and I can show you how to do that on the private side. I can show you how to do that on the private side and make their ass liable for the taxes because they ain't doing nothing but going into the children's social security trust account, getting the money to fund the whole operation, and then sticking you and leaving you with the tax bill. You can't handle the truth. I meant, what about doing business from a trust? Sorry for the typos. Yeah, you can do business from a trust. Shit, what do y'all think Donald Trump is doing? What do y'all think Donald Trump does? He operates his businesses out of trust, man. That ain't nothing. Everybody know you could do that, but it's cool to do that, and you can circumvent a lot of so-called taxes owed that way as it relates to corporate taxes. Basically, you had the corporation reroute funds to the damn trust, and because remember, the trust is supposed to be private unless you in a court issue. Like I said, unless you're in a court issue, your trust is private. So the trust ain't open for interpretation as it relates to the IRS. Yeah, the general services accounting bonds. Yeah, Jamie Monteson. Do you sign your kid? Wait a second. DM said, do you sign your kids under the trust to protect them? Yeah, well, you want to appoint them as beneficiaries to your trust. Exactly. Go on spool and they don't get it. They don't get it. You know what I'm saying? They don't get it, yo. That's a very good point you just said. Own nothing, control everything. You never had nothing registered with the state or anything that's a descendant from being a creation of the state in your name. Juan Hood, you crazy, dude. You said I need to clean up my credit. Should I do bankruptcy? Look, I'll be honest with you. If you owe some people crazy amounts of money, and if you can always go back and I'm sorry, Jamie. I'm thinking of uh the GSA bonds themselves. My brain is scrambling right now. But Juan, you said I need to clean up my credit. Should I do bankruptcy? Man, nobody should ever be in bankruptcy court. But like I said last week, I said if you in a situation to where you got alleged creditors that just keep attacking your ass, and it's like you can't catch a break, and as long as you can come up with a contingency bankrupt plan where a lot of your alleged creditors will be okay with it, you can do it. I still don't suggest you doing it though. I don't suggest nobody should ever be in bankruptcy court. Nobody. Because it's your credit that they're using. Your credit that they're using. And they holding you liable for all of the taxable income bills. All of this is tax law. So you talking about they messing uh with your credit reports and all of that, and they coming after you. No, they coming after the taxes owed from the estate. But you still shouldn't be in Chapter 7, Chapter 11, no bankruptcy court. Unless you didn't, you know what I'm saying? Now, if you, like I said, if you didn't gank people out of some millions or some shit like that, then yeah, it's a tax issue, right, Jamie? It's a tax issue. You can't ever be bankrupt. It's always a tax issue. Dim said, I meant protecting them from being wards of the state. Or is that the UCC one? I should do secured party creditor. Man, well, you got a long way to go. Let me say this about everybody that's trying to do this whole secured party creditor shit, and you guys don't even know what it means. If you don't understand accounting, general accounting, if you don't understand tax law, if you don't understand trust law, if you don't understand the Uniform Commercial Code, you're never going to be a secured party creditor, ever, because you can't handle your own affairs. And that's not me putting you down. That's just me actually, getting on you to cut the television off, leave the strip clubs alone, stop, blowing your money on stupid shit. Put your face into these books so you understand how to operate in this system. Everybody that think that they going around just filling out the UCC ones and all of that, UCC one itself is probably arguably the most misrepresented document out there. The UCC one is nothing but a notice that there is a lien associated with the straw man. But what I'm saying is that you guys will never be a secure party creditor because you don't even know what it is. You're talking about being a secure party creditor, but if I ask you anything as it relates to Article 9 of the UCC, you can't tell me. And Golden Spoon, you're absolutely correct. It's all about how you operate. You don't even have to be a secure party creditor and still know how to operate in commerce. That's what I'm trying to get everybody to understand. Paperwork is nothing. You're absolutely correct. When they read this shit, all these Secretary of State officers, they look at that shit and they ball that shit up because it's laughable. Because I see how you guys even carry yourselves as it relates to some of these questions that you ask. And I'm not saying this one to beat you down or nothing. I'm just saying you gotta have a fundamental understanding of who you are first. Because Jamie just said it, he said it best. It's your straw man's credit report. It ain't your credit report. You are a creditor, but you don't know how to operate from that standpoint. And the fact that you don't know how to operate from that standpoint, you allow people to take advantage of you. This is all about them taking advantage of our ignorance. We are all ignorant to a lot of things. Nobody knows everything. But what I'm saying is that you have to learn how to operate from a capacity in which you are comfortable doing. Nobody should be filling out paperwork and you don't even know what it for. First of all, you don't even know what it is. And then number two, you don't even understand why you can do these things. And then you're just basically setting yourself up to get in a lot of trouble. That's what happened with a lot of people that was doing promissory notes, A4Vs, all of this stuff back in 07, 08, 09. Justin Cole said, who are you in commerce? Exactly. You have to understand who you are in commerce. It's all a game, but you got to understand the hats, how to play the game, things of that nature. I'm going to go back and I see your email that you uploaded and everything like that. I'm going to go ahead and I'm going to get with you. But for everybody that I was saying that wanted to get together and you guys want to come together and help each other learn, I don't know everything myself. I'm still learning as I go along with all of this. And I learned a lot from you guys. Like last week, I looked at so many cases that, you know what I'm saying, in Google Scholar. It's just a free service, but I learned that from you guys as well. But what I'm saying is that if you guys still want to come together and get some type of a private group going in which we all can contribute, I'm more than, willing to come forth and, we can do that. But let's go ahead and, ask some more questions. Got about another 40 minutes, so let's go ahead and keep rocking out. I want to say thank you to everybody for tuning in as well. You guys remind me before this stream is over not to forget to upload the PDF version of the revocable trust so you guys can look at that. And don't just copy it and fill in your stuff and think, oh yeah, I got a trust now. No, look into it. Use the etymology dictionary as well as get you a Black's Law dictionary and go back and translate a lot of these legal terms before you just go ahead and start signing your signature on some stuff. So remind me to upload the PDF for the revocable trust as well as the video itself so you guys can go back and watch the presentation that when I tried to go ahead and play it, it didn't allow the audio feed to cipher through. But yeah, we all can do that, you guys. If you guys want to come together and like I said, if you guys want to form a group, we could do it on we can still remember we can stream privately on YouTube. It ain't gotta be open to the public. We could stream privately and we can all come together. We could give each other homework. Like, okay, somebody looking to trust law, somebody looking to restatements, somebody looking to the commercial code, somebody looking to court proceedings, rules, regulations, city ordinances, stuff like that, yo. T-Bat said, can you do another Q&A next Friday? Yeah, I'll do it. I'll do it as long as I continue to get participation. The minute I start seeing 2 and 3 people, that's cool, but I would like it. You know what I'm saying? This is cool right here. It's 22 people watching right now. I would like it to be about maybe 30 to 50, but shit, this is still cool right here. I appreciate you guys can be doing anything in the world right now. It's Friday night. You can be turning up or doing whatever, but you here watching me, and I appreciate that, and I acknowledge every last one of you guys for that. But yeah, I'm gonna continue to do the Q&As because I understand they help a lot of people. Because, like I said, I think what it is, a lot of people, they don't want to ask questions in the chat room because they might be kind of like not ashamed, but they kind of might be timid, or they might, have like something personal. And I get that they don't really want to disclose or share with everybody. But I enjoy doing the Q&As now because it gives me a chance to kind of interact with the people and see where the people's mindset is at, as opposed to how I would just previously upload a video and I would just go from based off everybody's comments and stuff like that. you know Juan Hood said, I'm ready. Have you heard of the IRS form 706? Yeah, the 706, that's basically the estate tax form. That's basically, what I'm saying, you doing the taxes for the estate. And some people say that you have to, let me set the record straight on that real quick. Some people always say that you have to declare the estate itself as being a dead entity. No, you don't, because like I said, after 7 years, you lost anyway. You lost anyway, but you can always come back and still do the estate, but you have to have a will in place and you have to have a trust in place. So the IRS can verify that there is a trust as well as a will to the estate before you go using the 706. Sorry, sorry I'm late, guys. No, you good, man. Hell, you made it. I appreciate you for being here. You good. You didn't miss nothing. You can always go back. I'm gonna leave the stream up so you can always go back and look at the live stream as well. Jamie said, T-Bat, avoid participating in public controversy. That's very true. Very true. I mean, you could you could participate in it if you want to, but if like I know, that's a good point that you just made, Jamie. You kind of want to you keep your private affairs in the private. If you into the whole Democrats, Republics, and all, man, that's crazy nonsense. You leave that for the United States citizens that like being bonded, chattel debt slaves. Or what is the national debt now? I just looked at it the other day, 21 trillion. But I mean, that's cool. To each his own. I'm not knocking them, but they got a lot of growing up to do. What books to start with? I always like promoing, since everything is a class 5 given estate as it relates to your straw man, you kind of want to look into Alexander Bowles, The Complete Book of Wills, Trust, and Estates. That's one. Number two, you want to read your state's constitution, because like I said, you can still operate just as like a common person. If you know how to stay out of their jurisdiction and stay out of adhesion contracts with them, they get everything, they do everything to the people through contract. And it starts with the birth certificate. And then after the birth certificate, along comes all the other adhesion contracts. If you learn how to stay out of their jurisdiction and you stay in the private and out of the public, you'll never have an issue. You'll never have an issue. The minute you go getting a driver's license, and let me not say that because I don't want to put that out there. The minute you start, how can I put it? I'm gonna say this correctly, affecting interstate commerce, the minute you start terrorizing public officials by sending them all this crazy shit, the minute you start operating, Jamie just said it best, and participating in public controversy, is the minute the democracy is going to continue to kick your ass in your face. The minute you revert back over to the republic and then the private is when you'll start winning. As far as T-Bat said, as far as trust law is concerned, what other books do you recommend? Well, I plugged them. The Restatement, second edition of Trust. I'll go back and I'll screen share that real quick so everybody. It's like $98. Unless you guys can find it on the American Book Warehouse, I think it's $98 a book. Uh, that's a core question is what are some pointers on how to get the original promissory note to my house? Because I still don't know the steps to take. Well, the promissory note is basically an investment contract, and it is an investment contract that's being held by the title security or the servicing company, and they hold those promissory notes because those promissory notes are taxable. The bank doesn't have the goddamn promissory notes, contrary to what people think, because the banks will have to report in the banks will have to report the promissory notes as cash flow on their daily, what is that? Damn, what's that? Daily currency transaction log or something like that. I know Gene was talking about that a little bit, and they hold 100% tax liability because remember the deed of trust is is held with the county recorder's office. So you abandoned the deed of trust and you abandoned the promissory note. What April Charney was trying to do back in '07, '08, '09, and all of that, uh, she did some good things, but when she was asking the banks to produce the note, they went back to the drawing board too. They said, okay, well, the court is acknowledging the fact that most of these homeowners want us to produce the note, and we don't have the note because we didn't sold the note, or we just not even in possession of the note. They went back to the drawing board and said, you know what, we're not even, you know what I'm saying, gonna hold it. So what I'm finding is a lot of people that's deal with the mortgage foreclosures and shit like that. They go and they see they've been able to find the release of lien on the mortgage in the county recorder's office under the miscellaneous files and stuff like that, but they haven't been able to locate the promissory notes. Oh wow, overcomers with our words said, what's up, Dre? Regarding the W2W4s, 21.7.5 estate tax return, what percentage of CPA's tax preparers do you think? No, oh, come on now. They all know. Come on now, you know better than that. They know every C. Listen, the only difference is between a CPA and a damn state lawyer is the fact that one just basically want to be hit up when it's involving the money. Like, look, don't call me, don't bother me unless they don't want the bullshit that's associated with going in and out of courtrooms and shit like that. But they all know. They all know. You got to remember these people. It's like they all miss their calling, if you ask me, because they all are actors. If you're a CPA or if you are a lawyer of any kind of nature as it pertains to any form of law, you are a paid actor, is what you are. But that was a good question. But I mean, come on, man. That's like, yeah, come on. You know better than that. They all know what's going on. Jamie said, T-Bat, when you're saying holding everybody in equity, what does that mean? Well, that mean that you have an equitable claim to the estate as it relates to a court case. That's what holding everybody in equity mean. Meaning the prosecution, the state, whoever. Remember, this is all backwards because the people make up the state. So this corporate fiction shit is coming in, under the Emergency War Powers Act as well as the Buck Act of '48. They didn't form some damn corporation behind the people to make up the state's back and are presenting themselves as an alleged creditor. Now, what they are doing is basically billing your estate for a statute that they claim that your person is in violation of violating. But when she was referring to, I said that earlier when I said you hold them in equity. That's how you access the common law side of the court by holding them in trust law and under trust law, and you keep them there. You don't let them revert back to the admiralty side of the court. So you gotta understand, like, when they switch sides on people and how they try to switch sides on people. So looking into admitting to 1040 would be a good idea. Can you? No, 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 no. Don't admit if you already sent it out. Ain't no point of going back now. Just let it rock. And then think of it this way. Don't. Why would you amend to 1040 now? To do what? Just because you seen me, pull it up and state that the W2s, W4s, and W3s is all class fives? No. You've been doing it this year. You've been filing it incorrectly, so file it incorrectly this year. What you do is you take this year and up until April of next year to study so you can do it correctly next year. That's how you do that. Don't rush this. You can't rush this. That's another problem that I think a lot of people they mess up and they get the rushing things and because they find out about something and they want to, oh damn, let me apply that, let me try that. You got to study the technique first, and then after you master the technique, then you can apply it to your situation. But don't, ain't no point in changing it now. But yeah, every CPA, every lawyer, every judge, every magistrate, they all know what's going on. It's all smoke and mirrors. They all know what's going on. But you got to remember how they make their money is through bankruptcy. Because if everybody was operating in gold or silver, they got to go home and they got to go pick another profession. They can't, you know what I'm saying? They listen, they operating in bankruptcy. So naturally they gonna uphold everything as it pertains to bankruptcy. And what's bankruptcy? When you bankrupt, you dead. What did I just show you guys in Rule 17? Real party and interest, probate terms, dead entities. So this is how they getting their bread. So I mean, I understand the game now in which how they operating. Are they deceiving the people? Yes. But do the people hold responsibility in taking it upon themselves to find out what's going on? Yes. The people are the ones to blame for all of this. Because everybody, listen, I just said, all you gotta do is go to the national debt clock. 21 trillion. Why aren't the United States citizens up in arms about that? I don't get it. Because it's one big ass welfare country. A lot of people always say United States is the richest country on earth. No, it's not. It has the most debt and it's the most bankrupt. That's why they confiscated everybody's gold and silver, and you can't operate in that. You can operate in that capacity and avoid paying taxes. But if you get caught hoarding gold, because remember, hoarding gold is still against public policy, pursuant to Public Law 73-1048, Chap 40, Stat 48, Chap 48. Justin Cole said, "Y'all better get your study game up, or you're going to catch a public trial." Basically, sooner or later, you're gonna get an issue in the public because the law merchant, the law merchants that write the UCC, they write it from a beneficial standpoint for them to be able to collect tax revenue on the private side to pay back the national debt, which they don't ever really have any real intent to pay back because it's not backed by anything. FRNs are not backed by anything. But how they insure themselves is by selling bonds internationally. Meaning that if the United States citizens don't pay up on bonds, they got shit called missiles and assault rifles and public warfare and martial law, which the United States is still technically under to this day. They got Lieber Code laws. So I mean, this shit been going on almost, realistically, it's been going on almost 200 years now. Gossip Corp said, so if my mortgage is paid in full, I can still sue the bank for not producing the original note. You can, man, but I have seen, listen, I have seen people that is heavy with this. You can, but it is extremely hard. And because the banks is tied in with the courts. The banks is tied, the banks insure the court investment registry system. Banks do. Banks put up bonds to ensure the court investment registry system in which your state's treasury department invests in. So, and most of those disbursement of funds, when your state puts out what's called its CAFRA report. If you guys don't know what a CAFRA report is, go ahead and look at your CAFRA report for your state. and you will see the disbursement from the court investment registry system, which is insured. I don't know if I should put that out. It's insured by, let's just say, maybe three large banks in the United States. One of them being extremely notoriously private and cutthroat. And I don't really want to put that out there. But you can. I'm not saying that you can't. I'm not trying to discourage you from doing it. But I would say you gotta find the non-disclosure as it relates to your deed of trust, or if you got a warranty deed, either or. Exactly, Jamie. Yep. A CAFR report, comprehensive annual financial report. The courts are financial institutions. The court is nothing but a bank, and they put up the insurance bonds to ensure that the Chris basically won't get bothered or affected. That's where all of the money is generated from the public via police officers pulling people over, traffic tickets, child support, enforcement orders. All of this shit is its intent is to pay down a national debt. This is why, don't you guys understand why? This is why they have so many laws where if you spit on a certain sidewalk, you can be prosecuted, because it's all about enslavement. Marie said, damn, everything is a bank, it seems like. Exactly. That's what it is. That's what I mean when I say, like, okay, when I talked about the whole secured party. If you're a secured party, basically you saying that you're a private banker because you know how to handle the taxable affairs related to an estate. See, people think that, oh, I'm a secure party. That mean leave me alone. No, a creditor pays his bills. So if you're a secure party, that means you know how to pay your bills on the private side. You don't need to operate in FRNs unless, and even when you do operate in FRNs, you understand their obligations to the United States corporation, and that those two have to be reported back. And any letter or of credit or evidence of indebtedness that is in the amount of $10 or more has to be reported back. You damn straight. He said, T-Bat said, what the hell are they teaching us in college? The real education is right here. I appreciate that. What you are learning in college, you are learning how to become what would I call it? A workforce slave. You are learning how not to develop your critical thinking skills, and you are basically being groomed for a continuation of being a law-abiding, tax-paying citizen. Which, hey, I'm not a tax protester. Let me say that I'm not a tax protester, but you taught that if you have a debt, you pay them with Federal Reserve notes. Jamie said the tax liability, the IT, exactly. Exactly. Maurice said, I guess we live in commerce, literally. Everything that you do in the public is under commercial law. Everything. The reason why it's under commercial law is because there's no money anymore. And it hasn't been any money since June 5th of 33. So everything that you do is going to naturally be under commerce. Everything that you do, Mo, is going to be under commerce. This is why you in particular, and I got your email as well. This is why you in particular, you need to really dig deep and study all of the Uniform Commercial Code, because the shit that you going through right now, you can handle that by writing a letter, but you can't just take DreChilly's letter because, oh, it read good and I'm gonna send it out. They know you just like, you don't know how to enforce it. So they like, all right, he sent us a letter, but we're not even gonna respond to his presentment, even though now he didn't basically threw the ball back on our court and we have to respond, otherwise he can hold us in default. But if they know you don't know how to enforce it, they like, man, look at this shit. You can tell he just copied this from somebody off the internet. It's crazy. Yeah, we'll sign for it. And we know he don't know what he's doing. So that's what I'm saying. You got to go back and read the Uniform Commercial Code. And in particular, you got to go read Article 3. Justin Cole said they monetize everything. Maurice said, you forgot to mention learn how to accumulate fake debt. Oh yeah, basically. And that's a good one, because that's basically what everybody is doing. You're accumulating fake debt. That's kind of what oh yeah, it's funny you mentioned that, because that's what I wanted to talk about, and didn't nobody remind me. But I wanted to touch on some of the so-called student loans. If you guys have any student loans that you guys want to discharge, there is a promissory. Well, it's not. I wouldn't call it. Well, no, I said that wrong. It's a promissory note if you're a secured party creditor that one can use. But I don't recommend it because I know that people don't know how to basically pay the taxes associated with the promissory notes. I'm not going to push that out. However, I am working on another validation letter, and it's cold. It's so fucking airtight. It's so airtight that they might even snatch the video down, because I'm gonna show you guys how to do it in both the public and on the private side. And it's so cold, but I'm gonna upload that video, so you guys be on the lookout for that one. But I'm gonna put it out there, and it's cold because I got every statute that's applicable, whether it be, state statutory offenses, or whether it be United States code offenses as it relates to student loan debt. But you know what I'm saying, we got this under control. We all coming together. Don't forget to P that. All right, DM, thanks. I won't. Jamie said, we are in a sea of commerce. The vessel is created for our benefit when we know how to use it the right way. Exactly. The vessel is not a bad thing if you know how to operate the seas. That's why I showed Jamie. I don't think you was in here, but I showed everybody that video, and I want everybody to go back and watch that video of that man who basically handed them the documentation of title to the vessel back to the damn he put it back. He took his vessel from off land and put it in sea, all while reserving his rights under the common law, using the UCC in doing so, because he expressed trust. This is kind of like when you said, well, what does she mean by expressing trust? He expressed trust in that video orally, because you can create your own trust orally, and he did it as a trustee to that vessel. But he gave that vessel to the waters. He threw that motherfucker right back over, and he didn't cross the bar, and he threw it on the water, and all while staying on dry dock. It was so cold how he did that. He said they did this so we will not drown. Golden Spool said 18 USC 8 will tell you what are obligations of the United States, from checks, money orders, all that shit is our obligations of the United States. Don't put that out. Email me. I'm telling you, it's so cold, yo. Because I've been using everything. What you guys got to do, you got to learn how to use their codes against them, and you got to understand how to enforce them. The people got the power. It's just we not using it. Okay, drop your email one more time. You can't handle the truth. In fact, do you know how to send me a message on YouTube? That way, if you send me a message on YouTube, I can go ahead and I'll be sure to make sure that I shoot you an email. That's the key. Enforcement. Exactly, T-Bat. People don't know how to enforce nothing because they don't know how to do an administrative process. And another thing that you guys don't, not you guys, I'm generally speaking, so nobody take this personally, but another thing that people don't know how to do, they don't read the administrative codes in their states. You have to read the administrative codes in your state, because the administrative codes will tell you that any regulatory condition that these agencies, whether they be public officials or state governments are using, they have to abide by administrative law. And this is the power of an administrative process if you know how to do it correctly. So that way, when you go into court and you ask for summary judgment, it ain't no more playing around, because all the facts and evidence have already been displayed, and you just basically filling in all the paperwork for the straw man, so the straw man can be redeemed. Whether it be a suit in equity or whether it be a suit in admiralty, either or, it don't matter. You gotta know how to play on both sides of the court. This is why people not winning. It's about time that the people just start winning on everything, whether it's credit card statements, somebody putting something on your credit report, any of that, traffic tickets, any of it. And the reason why a lot of people be like, damn, why did Dre go over traffic so much? Because 90% of people getting in trouble starts with traffic violations. And you don't even understand that unless you operating in a commercial capacity, you ain't in fucking traffic. And the reason why I cover that so much is because that is essential to all of this, because the police department for the insurance companies, because all cities are nothing more but fronts for insurance companies. Uh, what are y'all talking about, Daniel Jordan? Don't come in here trolling. Like, what do it look like I'm talking about? Read the actual title of the video. If you come in here trolling, you're getting blocked. So you've been forewarned. But back to what I was saying, the cities are nothing but fronts for insurance companies, and a lot of this shit starts at the lower level because these police officers think that these people give a fuck about them, and they don't give a fuck about them either. The prosecutor understands that you need the garbage man out there, harassing people and writing these taxable negotiable instruments in order to keep their ass in business. So they all put up the insurance bond, or a hazard bond as they call them for the police forces, and make them go out and pull people over and put their life on the line. And then literally the police officers know these people don't give a fuck about them when they get their head blown off. And some of them they know what's going on. Some of them think that they just, arm protecting the community and witches stands and stuff like that. But they don't understand the full scope of what's going on. So we kind of got to, I'm not a police basher either, because you kind of got to give them the benefit of the doubt, because we was, in the dark at one point just like them. So I'm not, that's why if you guys ever notice, I've never really bashed police officers or things of that nature, because don't get me wrong, I talk a lot of shit, but you still kind of need somebody to go out there and check the bullets. All right, you gone. Get your ass the fuck up out of here. You must not know about me, buddy. The whole goddamn police force where I'm at, they know of me. And when they see me, they just look and they see who it is and they keep riding. I could be doing, and I'm not saying it's to brag, but I could be doing 60 and a fucking 40. Facts. Let's see you handle the law enforcement in your local area. So kick rocks. Get your troll ass the fuck on. Exactly. Andrew Martinez, what is trollster? So I won't do it. Well, trolling was what that motherfucker just did. So if you want some bullshit too, then you know what I'm saying, you get your ass on too. You ousted as well. So it depends on what question you ask. If you come up in here with some bullshit, then you get out. You ousted. But somebody asks, like maybe 3 more people ask some questions real quick before the 8 o'clock hour comes. Yeah, some old troll ass motherfucker come up in here talking about what are you talking about? Man, get the fuck on. We definitely not talking about the stupid ass shit that you want to talk about. We talking about how to handle presentments, how to handle ourselves in commerce, and how to regulate and run shit. This shit is real powerful. That's what we talking about. We talking about big time shit. You take your little shit dropping ass the fuck on somewhere. You little rat shit producers. Get on somewhere with that bullshit, punk. Shut up, punk. Punny down. Wealth and Health said Dre was at Fidelity today trying to get the QC number. It was not successful. Broker stated that needed 3 things. Man, just email me on the private. I got like 10 minutes. I got some shit I gotta go do. But email me on the private side, Health and Wealth. I'll show you how to get that shit. Geopolitics said, saying with the clerk sitting behind the desk, let's be respectful. Most of the time they're not aware of what's going on. Yo, what incident woke Dre up? No, just some fucking trolls. They come up in this bitch trolling. Occasionally they'll send their little agents out, their little, bent over ass, United We Stand and all that old bullshit. Them type of trolls and shit like that. People that are so dumb and so fucking retarded and can barely spell their name and shit like that. So you got to deal with a few of them little ass wipes in this sector. But like I said, they punks and they don't even believe in themselves. So it's not even really worth discussing them no more. The maturity date, coupon date, and the company name. Okay, yeah. So you got to go read IRS publication 1212. it talks about how to get the QSIP number associated with the 1099 OID, as well as you need to go read the 1099 publication that covers the A as well as the C. It's all in there. If you read publication 1212, it'll have a link, it'll have a cross link showing you the publication that's associated with the 1099 and how to get the QSIP number on the form 8182. I think he was asking what inspired your journey to truth. No, he wasn't. I took that as a motherfucker that was trolling. I took that as a motherfucker who's in here trolling. Justin Cole said, "Oh no, I wasn't talking to Justin Cole. I was talking about the guy who had the SpongeBob picture. What incident woke you? Oh, okay, my bad. I see what you're saying now. Sorry about that, you guys. Justin Cole. That's probably the best question I didn't had all night. Truth be told, I'm gonna make a video about that. I'm not gonna disclose that. I'm gonna make a video about what inspired and what woke DreChilly up. I'm gonna make a whole video about that, yo. So that's coming, cause it's kind of I'll be over, the 8 o'clock hour, and I said I was gonna get up off here at 8 o'clock, but I'm gonna make a whole video about that. So stay tuned. But just know that it's pretty much it's simple, but it said, okay, I see what they're doing and I see how they're getting the people. So now I got to get off my ass and I got to put things in motion and I got to, sharpen up the actual knives in the drawer. Plus, I'm coming from an advantage as well. I'm not going to front. I'm not going to sit up here and act like I didn't have a helping hand in all of this. If you got some people that's lawyers in your family, or if you got people that's paralegals in your family, you get exposure to a lot of things that the average person never gets exposure to. How could I message you on YouTube? Didn't know you could do so. Yeah, you go to the community settings on my channel and then you type in a private message like that. When I did sent back a ticket the way you did a video, just waiting to see what happens. They're not going to be able to respond to it. If you did it exactly the way I told you to do it on my video, they're not going to be able to respond to it because they can't respond to it. Why? Because you used the Uniform Commercial Code as a defense and you explicitly reserved your rights. And you also have the ticket notary seal affixed on the ticket itself. So they can't respond because what? A notary public is also an officer of the court, and an officer of the court can also be what's the word I'm looking for? Cross-examined. And you can use that same notary and do a notary protest. What about credit cards, accounts? Do they have maturity dates? Exactly, they do. That's what he's referring to when he's asking you for the maturity date associated with the uh interest. The interest, okay, the interest stated on the initial credit card application is usually the maturity date. Like, okay, if you open up an account and they say zero financing associated with this credit card for up to 12 months, 12 to 18 months, something like that. Have you read the Top Secret Banker's Manual? I got that. Banker Secrets, domestic violence woke me. That woke a lot of people, yo, because you see how easy a motherfucker basically can just be accused of anything, and then you will see how they coming to get you. They putting the cuffs on you, so that will wake a lot of people up, yo. That'll wake a lot of people up. Geopolita said, I was reading that banker's manual last night. Very good info. Thanks for telling us about the Wills, Estates, and Trust book. That's a good book. Yeah, of course. Yeah. How long? Wait a second. How long did it take to you get your refund from the OID process? I don't see. I'm totally different. Like I file my taxes in October. Like I'll automatically request for the extension because I'm not done. I'm not done collecting my credit back. If you know what I'm saying. So mine might take 10 months. If October is the 10th month, that's when I'm filing my taxes. So it might take me 10 months. And then I'm taking 2 months off just to play around. So to each his own. I mean, it depends on how many 1040. You're really only supposed to file one 1040 anyway, but you can file two of them. But it's a penalty, and then when they assess the penalty for filing two of them, I just charge it back to the IRS and make the IRS pay taxes for using my credit against the chargeback number, which is their Social Security account. That's how you do that. You know what I'm saying? You could, like I said, I play around for at least 2 months out of the year, and I'm getting all of my credit back when I do file. So usually, I'm getting my return around Christmas time. One last question, then I'm gonna let everybody go. Somebody come with a good one. Somebody come with a good one. Once again, thanks everybody for tuning in. You guys remind me to upload the creation of the trust video so you guys can go back and review that, as well as I'm gonna drop a link that I want everybody to go back and go watch that video that I showed you guys earlier with the screen share, where the dude had expressed trust in court, and he threw the damn vessel on the waters, on the high seas. He threw the vessel, which is the birth certificate, on the high seas, and he expressed that he was throwing it to them in that jurisdiction from the land. What did he say? You said Justin Cole said, "Who sheriff in AZ or who sheriff in as now who follow Constitution?" Next Friday, same time. Yeah, next Friday, same time. Two Gun said, going to study up. If you get time, read up on that NY case. Thanks. Of course, I'm gonna go ahead and read up on it. I think you said what sheriff in AZ now who follow the Constitution. Well, like I said, as much shit as I talk, don't get me wrong. I I talk a lot of shit, but the public officials out here, as of late, they been on it, yo. They ain't really been bothering the people. I can't front. I'm not gonna get on here a lot. I can't front. They haven't really. They've been staying within their bounds. The harassment from the city police in a lot of cities in Arizona, because I understand what they trying to do. They trying to they trying to generate revenue for the insurance companies. But as far as the sheriffs, they, truth be told, the deputies, man, and the county sheriff's departments, they rarely do you see them pull somebody over and be on that ticket shit and harassing people, yo. Now they gotta come get you, you know what I'm saying, if it's a murder case involved or something like that, because by default, the it gotta go to a court of record. You know, it's not staying on a municipal level, so it's by default it's going to them. But outside of a murder case, man, the sheriffs, Mark Napier, and what's the other dude's name? I can't think of the other dude's name, but for the most part, man, they kind of, they straight, they all right. They ain't really. You rarely do you see them fucking with the people, and that's just my whole attitude as it relates to myself. Like, I ain't out here trying to be Robin Hood, but as it relates to DreChilly, they all kind of know who I am, and as long as I'm not destroying public property, as long as I am not invading on another person's rights, because your rights stop the minute you invade on somebody else's rights and remedies. As long as I'm not doing any of that, they leave me the fuck alone, you know. So hopefully that answers your question. You guys, look, it was great. I appreciate everybody for tuning in. I'm going to go ahead and upload that stuff. Give me like 10 minutes. I'm going to come back and I'm going to upload all that stuff so you guys can go ahead and watch the playback on that. Sorry that we wasn't able to watch it together and that we was able to go ahead and uh kind of like intersect and go back and forth as it was planned. I got to figure out how to, operate this platform a little bit better. Most definitely. I appreciate everybody. And we're gonna do it again next Friday, same time. What do you guys want to talk about? Give me some suggestions before I let everybody go right now. What do you guys want to talk about? Because if not, I was just going to label it as Q&A with DreChilly. But what do you guys want to talk about? Billy Two Guns. My daughter keeps getting photo notification for speeding in Scottsdale, not tickets. Yeah, because we got rid of the state. That was the one time where the people came together and they had some sense and they said, "Well, shit, uh, this man, I can't think of his name. He had a monopoly basically on the photo traffic enforcement cameras in the state." And they was like, "Why are we letting one person continue to get rich?" And why are we putting the element of traffic citations in the hands of a damn camera as opposed to police officers? Safe travels to everybody as well. No drinking and driving either. No drinking and driving. But what do you guys want to talk about? T-Bat said pertinent UCC codes and how to enforce them in court. Okay, we can go over that. Did I got somebody that is second that? Or does somebody want to talk about something else? It don't matter. Court and commerce. You got, what do you guys want to cover? Be more specific. She's the only one listing some stuff. What do you guys want to cover? Type it in real quick and I'm gonna let everybody go. Getting rid of debt. Trademark name, deregister agent, getting rid of debt. Okay, we'll do those three. We'll do can we write the UCC code on return mail, responding mail to creditor's claim? And then we have, of course, it's applicable to your state. If a business is registered with the Corporation Commission under the Articles of Incorporation in your state, it's applicable to that state legislation. So we're gonna go into, okay, I see you guys like the UCC stuff. So we're gonna go into the UCC, how to operate in commerce and the court, and getting rid of debt. Alpha Majestic, I appreciate you guys. Justin Cole, Health and Wealth, you can't handle the truth. T-Bat, everybody. You guys have a good weekend. Everybody be safe. Once again, no drinking and driving. If you do get pulled over, just give the police officer the driver's license, registration, proof of insurance. Do not show your ass out there on the side of the road. Think about making it back home. If you guys get a ticket, hit me up. Other than that, I'm going to go ahead and let everybody go. I appreciate peace and love. And always remember, power to the people and only in the people we shall trust. This is DreChilly signing out. Good night, everybody. Peace.